Hello, I'm Cherie with Caldwell Banker United Realtors, and I'm here today with Cheryl Fike with Fleet Perry Ritchie in Navarre, Florida. And today we're conducting this video to help you understand the closing process. You know, over the years I've realized that a lot of buyers and sellers are not familiar with the closing process, also referred to as settlement. So Cheryl is going to help us understand this closing process today. Cheryl, what is your primary function in a real estate transaction?
Our primary function is to convey title from a seller to a buyer through warranty deed or a leasehold deed, and also encumber the property with a mortgage if the buyer is getting financing.
Wonderful. And what is title?
Title is where we actually search the property and make sure there's no liens, mortgages, judgments that are recorded, so that when we do convey title to the buyer, that it's free and clear of all encumbrances.
So when you say that you want to make sure that there's no judgments or anything on the title, is that what they refer to as cloud on the title?
Yes, that is correct.
Mm-hmm.
Anytime a buyer or a seller has anything that's against their name, or if they've has a judgment, a lien, unpaid taxes, mortgages, anything like that, is a cloud on the title that we have to clear.
What is a warranty deed?
A warranty deed is where the seller is actually giving the buyer clear title to the property that they're selling. It's a guarantee that there are no liens, judgments, or anything on that property.
I see. Another term that's used quite often is HUD. What is a HUD?
A HUD is also referred to as a closing statement. This is the form that has all the numbers, your sale price, your loan amount, all the charges that are going to be on that property, whether it's a survey or termite, insurance. It'll all be on the HUD, or what they call now a settlement statement.
Okay. And who do you actually represent in the transaction?
We, as a title agent, closer, we're an intermediary person. We are neutral. We do not represent the buyer, the seller, or the lender. We're merely there to conduct the transaction and make sure that we remain neutral.
Why is the spouse required to sign the deed when they're not on title?
In the state of Florida, they have what they call homestead rights. Even though the spouse may not be on the deed, they must sign the deed in order to convey, as well as the mortgage. Even though it's not their primary, if it's their primary residence, they must sign the mortgage in order for the lender to secure that homestead. If they are, if it's investment property, commercial property, and they're not on title, then they don't need to sign. It only refers to homestead property.
I see. And what if they're separated? And they've been separated for years?
That's a good question. If they're separated for years in the state of Florida, they don't recognize, you're either married or not. So they would have to find that spouse, and they would have to sign that deed or mortgage if it's their primary residence.
What if they're not able to find the spouse? They've been separated so many years, there's no communication, and they cannot find the spouse.
They would have to take and go to the courts and file for a divorce and have the judge, but that's something they would have to seek the advice of an attorney.
Okay, great. Cheryl, you mentioned that a spouse has to sign the mortgage. If they're separated, are they still obligated to pay the mortgage?
The only time they would be obligated to pay the loan or the mortgage is if they sign a promissory note. If they're not on the loan itself and they just sign the mortgage, that's merely just for the homestead rights, but they are not obligated to pay for that.
Okay, because I know that's a big question that comes up quite often, so I definitely wanted to try and cover that. What are the different ways that a buyer can hold title on a property?
There are actually numerous different ways that they can hold title through LLCs, trusts, but the most common are your tenants in common, joint tenants with rights of survivorship, and husband and wife. Husband and wife, basically, if anything was to happen to either spouse, it would go to the surviving spouse. Tenants in common would actually go to their heirs. So there's actually numerous ways that you can hold it. And if they have any questions, they can always see an attorney for advice.
Why is a cashier check or wired funds required at closing?
We have to have a cashier's check or wired funds because when we complete that transaction, we have to take and pay the seller, pay off that seller's loan. And without those guaranteed funds, we can't do that. We would have to wait for the checks to clear. And that sometimes can take 2 weeks, 10 days.
Yeah, so that would cause the closing to extend way beyond the close date, which would be very inconvenient.
Correct.
Okay. What is required of the buyer and seller when they do come to the closing?
The things that we need to get from the buyer and the seller at closing is a valid driver's license, passport, or a military ID. The other thing that we need to make sure is if the buyer or seller have to bring funds to closing, that they have either brought their cashier's check or they've already had their wire transfer done.
Once the buyer and seller arrive at the closing appointment, how long does it typically take to complete the whole closing?
Typically it takes 45 minutes to an hour to complete the transaction. The buyer's portion takes a little bit longer than a seller. Usually a seller can be completed within 30 minutes and a buyer's can take 45 minutes to an hour, sometimes sooner depending upon the size of the loan package.
Well, Cheryl, you have really provided some real valuable information for our buyers and sellers. If they have any additional questions, what's the best way for them to reach you?
You can reach me at 850-939-9222 or my email, which is Cheryl, Cheryl, @pleatperry.com.
Great. Thank you so much, and we hope that this is helpful to you. Have a wonderful day.
Thank you.